Our next presenter, I think, is well known to most members. And if you're not a member, shame on you. Please become a member of AQUA, and you will be able to avail yourselves of the services of Graham Lilleyman. And Graham Lilleyman from ESSA will join me now and take about the next 20 minutes of your time before we open the exhibit hall. Thank you.
Hi, thanks for coming today. I've got a bit to go through, and some of it's a little bit tricky. There's been some difficult decisions from the Federal Court of late dealing with the issue of casual versus part-time employment, and also dealing with changes to the Vehicle Industry Award. And it's going to impact a little bit on some of the businesses here. So I just want to go through them as quickly as I can, and I'll take any questions afterwards. I'll be here for the next 2 days, so if anyone's got any questions, they want to come and see me at the booth, specifically for your circumstances, then feel free to do so. Okay, so the first one, there's been a change to the minimum engagement clause in the Vehicle Industry Award, which is the award that covers staff who work in car washes, hand car washes and self-serve car washes. The provision comes in from the 1st of October 2018, and it's inserted a clause which says there is a minimum 2-hour engagement for casual employees. So 2 hours. Previously, this award didn't have a minimum casual engagement. Right? Why it's relevant is because there's two situations where it's relevant. Some of the businesses are susceptible to weather, right? And you might want to send your staff home if it's raining or something like that, right? And you can't do that without paying them minimum 2 hours under the new rules. Previously, there was no minimum. You could just send them home, right? Under the new rules, there's a 2-hour minimum. Okay? The other thing it might affect is some of the smaller operations, potentially in the regional areas or something like that, where they only have a person just comes in, in the morning, checks, makes sure everything all right, changes the bins, that sort of thing for half an hour, goes home and then comes back later in the day and does the same thing. Now, previously, you could get away with paying the person just 30 minutes each time, right? Because there was no minimum. Under the new rules, if anyone's affected by this, you'll have to pay a 2-hour engagement for each occasion. So that will be 4 hours pay for that particular employee rather than the current half hour. It may not affect massive amounts of people, but it certainly will affect some, right? And it can also affect people if you decide to send your staff home because of weather, right? So, pouring down with rain, no one's going to wash their car, you've got a whole bunch of staff sitting there, right? Because historically, most people in this industry, or certainly a significant percentage of this industry, have been employed on a casual basis. Now, there's ways around that. Of course, you can just put people on permanent, right, for part-time rather than full-time, but that's the theory the government people will tell you. But unfortunately, we live in the real world. It's not so easy to do that, especially with the way that they've drafted the provisions in the award relating to casual and permanent conversion. Now, this particular clause has been in the award for some time. It has really largely been ignored by everybody, but it's going to become more important because of changes to this court decision that's come out, which has granted annual leave to a casual employee. Right? So I'm going to talk about that in a moment, but I want to just give you the background as to why this casual conversion clause is important. What you're supposed to do at the moment is, as a person's working as a regular casual for 6 months, you're supposed to go to them then and say, well, do you want to become permanent? The person concerned has then got a choice whether they want to become permanent or not. And if they do, they're part-time, 20 hours a week, they become permanent on 20 hours a week. They're full-time casuals, which is a bit dangerous these days, but if they're full-time casuals, and they're on 38 hours a week, then they become full-time on 38 hours a week. Now, what happens at 6 months, you're supposed to approach the employee and say, well, listen, do you want to become permanent or not? If you don't do that, it's just means that the person retains that right to come to you at any point along the line and say, I want to become a permanent employee. Why it's difficult is because there's very significant restrictions on how you can engage part-time employees under this award, and I'll show you them in a moment. Right? Once the person's been offered that time, they've got 4 weeks to decide what they want to do, and if they don't respond, they're deemed to have elected not to convert. Okay, so you go to them, and some people won't want to convert. In fact, a significant majority of people won't want to convert because the conversion process means immediately, in most cases, a significant reduction of pay, something in the vicinity of 20 to 25%, depending on what type of work you're doing and which classification of work you're doing. It's not so straightforward in this award to just say it's a straight 25% cut, because it's not. The way casual rates are worked out for some staff is a little bit different under this award. Okay? But it's a significant cut in pay. So if you don't particularly want the person to convert to permanent employment for a whole bunch of reasons, you might want to do that. The way you're just going to want to talk to them and say, listen, I've got this option for you. You can convert to permanent employment, but you're going to have your pay cut by 25%. That should scare a few of them off, right? So it's a matter of how you do it, but you're obligated under the terms of the award to do this, right? And because of the decision in this casual annual leave decision, it's going to become more of an issue, right? Because it's riskier to employ people as long-term casuals now until it's clarified what's going on. But the other problem we have under this award is that there's this part-time provision under the award, which says if you're going to convert to part-time, right, from a casual, you then, or if you're going to employ a part-time employee at the commencement of their employment, you have part-time employees, regular part-time employees, people who work less than full-time hours, of 38 hours a week, so less than that, have reasonably predictable hours of work and receive pro rata annual leave and sick leave, and that's the easy bit. Right? Where it gets difficult is that at the time of being employed, and this is also the time of conversion, if you have to convert somebody at the time of conversion, you have to agree with them the hours of work each day, the days on which they'll work, the actual starting and finishing times, and any variation to that must be in writing. All time must be worked, and excessively agreed hours must be paid at overtime rates. So if you're a part-time employee and you've got a seasonal business which can be affected by weather and things like that, and you've got to have part-time employees, those people still have to work those hours and they still have to be paid for those hours, even if they really can't do anything. Okay? So converting people to part-time has its challenges, especially in some industries, right? And depending on how you set up, some businesses such as a hand car wash who doesn't have a fully enclosed area and is subject to weather more than other top businesses could be very severely impacted, because they might have to employ some of these people as regular part-time employees, and if they do, and when they do, they could get washed out by the rain. You can't get any work done, no one's getting the car cleaned, and you're still stuck with paying the wages. So converting people to part-time has its challenges, and you have to be mindful of this particular provision. You have to agree with them in advance the hours of work each day and the days they'll work and the actual starting and finishing times. And if you want them to work extra, you've got to pay them overtime. Okay, so just be mindful when we talk about this casual versus part-time conversion issue. That's something that could be a problem for some businesses. The bit that I wanted to talk about now, I suppose, and it's relevant for this issue of whether you have people employ people on a casual or a part-time or a full-time basis, is that for a long time there's always been an issue out there about if you have someone called a permanent casual. Has anyone got permanent casuals in their mind? Just a quick hands up if you think you've got permanent casuals. Yeah, there's a lot of them do, right? People think they've got permanent casuals, but the one thing I can assure you you don't have is a permanent casual, right? Because there's no such thing as a permanent casual. The other person is either permanent, which they get annual leave and sick leave, or they're a casual, right, which they don't get annual leave and sick leave, and they get a 20 to 25% loading but to increase their wage rate based on the fact that they don't qualify for annual leave. Well, that was a decision until only a couple of months ago, where we've had this decision come out in Workpac v Skeen, and the problem being in this decision that this is a full bench decision of the federal court. And because it's a full bench decision, in the circumstances where similar circumstances apply, the lower courts are going to be bound to follow this decision because it's an appeal decision. Right? So what they found is that if where the employee works on a regular ongoing basis, where they have an ongoing expectation of work, they may well qualify for annual leave. Now, that means effectively the employee will be allowed to double dip. At the moment, they would get the annual leave, but there is no obligation to hand back the 25% loading that you get for the fact you're a casual. So at the moment, as a result of this decision, people are being allowed to double dip. Now, it's only one decision, but it's an appeal decision, and it's not like the Ombudsman's going to come charging off down to see all the car washes and say, well, you've got long-term casuals, you've got to give them annual leave now. It's not going to work like that. People will have to take this to court in order to get it, and there may be some changes, you know, eventually on this issue before we get down to the tin tax and work out what the real rules are. But there is now a significant risk for people who have long-term casual employees who are working on relatively regular rosters, and it's only relatively regular rosters that you could find yourself up for annual leave if it was to be contested. One fellow recently got 10 years worth of annual leave out of one of the big contracting companies for being a so-called permanent casual. Right? Now, this is obviously a highly contested issue. This was somewhat of a surprise, this decision, but that's what we're living with at the moment. And so WorkPac had a couple of choices. Well, they had several choices. They could appeal it to the High Court. The government could rewrite the legislation, the Fair Work Act, and try to correct this problem that they've got with the drafting of the Fair Work Act, which is causing this issue to arise. Now, the government can't get its act together on anything at the moment, so we're not expecting anything soon from them on that particular issue of redrafting. And the WorkPac have declined to take the matter to the High Court. Right? So what they have done is they're seeking a declaration in another matter that an employee of theirs who is a casual does not qualify for annual leave, does not get. So they made an application to the Federal Court for the Federal Court to make a declaration that all casual employees do not get annual leave and sick leave. Right? Or, in the alternate, right, if they have found that they do get annual leave and sick leave, depending on the circumstances, the employer is entitled to set that off against the casual loading that the person has got. Now, if either of those outcomes eventuate, then this problem will largely go away, right? But there is certainly no guarantee that that'll be the outcome. There's been a series of relatively consistent decisions in the opposite direction. But what has happened previously is that the issue of setting off or offsetting of the casual loading has not been tested. And that's going to be the real killer here, right? Because, I mean, it's more expensive to buy out a person's annual leave. So it's cheaper to buy a person's annual leave than to pay them the 25%. Annual leave doesn't cost 25%. So if that's the case, then there would be no point in anybody making a claim because they would be immediately set off against that and they would get nothing. So we're hoping that that will be the outcome of this application to the Federal Court. Now, the matter went to, on the 8th of November, on the 8th of October, went to the start of the process, went to the court for a directions hearing, and now on the 18th of November, it's going for a case management hearing in the Federal Court, this decision. Dan Feldman, who's the lawyer for HR Legal, who does some work for ACWA and some ACWA members, along with ourselves, I had a meeting with him last night, and as advice, he thinks that there's a chance we might get a decision on this year, right? Because the matter's critical. The government is intervening. The Liberal government is actually intervening in the matter, so they're trying to get involved in it as well because they see it as a simply an unfair scenario that's going on, right? But if we don't get a decision by the end of this year, we won't get anything till February or March of next year because nothing happens in January in the courts, right? So that being the case, and if that decision goes the wrong way, the Liberal government or the current government has still got the capacity to redraft legislation, but getting it through the Parliament and having that fight just before an election is probably something that's not going to happen. So if we don't get this declaration, if this declaration doesn't go the right way, we might be stuck with this problem for quite a while, right? And we don't know what the outcome's eventually going to be. Now, so having said that, what do you do in the meantime? Do you change everybody to permanent or not? Right? It's very hard to employ part-timers in this award, right? Unless you're depending on your business, right? Some people might be able to do it, but most are going to find it a problem. So what our view in general is, and it's up to each individual business to make their decision, and I'll run this past Dan Feldman as well, I say from HR Legal, is our view is that you should be using the casual conversion clause, going to your staff who you think might be an issue in a way that you think you can get the best outcome for yourself, and asking them, do they want to go into permanent, right? And if they do want to go, if they don't then want to go to permanent, they'll sign a document saying that they have been offered permanent employment, that they don't want it, that they understand that they are a casual, and that as a casual they do not get annual leave, sick leave and paid public holidays, and they can quit at any time and they can refuse a shift if they want to, and the boss doesn't have to give them any work going forward. And this is set out in a document that we've prepared. We haven't got it on our website at the moment because we're still getting it checked by the lawyers to see whether there's things that we need to put in there, and then get them to sign it, right? And in Dan's view, without having written this his view last night was that is probably going to be sufficient to take the danger out of this issue of the casual versus part-time claim. Unfortunately, some people might end up with people on part-time that they don't particularly want by doing this, and this is the risk you take, because your other alternative is to do nothing. And if you do nothing, the same status quo remains. An employee can come to you at some point and ask to be part-time, and then you've got to grant it unless there's good reason not to, right? But you would also be more exposed to the decision if that application by WorkPac doesn't go well. You'll be more exposed because you'll have these sort of permanent casuals without any documentation to say that's what they want to be, okay? So everyone needs to make decisions here about which way they're going to go, right? Everyone's circumstances are probably slightly different. And as I say, I'm happy to talk to individuals over the next 2 days on the at the Aqua booth, right? So just come up the back of the place and have a look for me, and I'll talk about an individual circumstances, and then you can make a decision, right? So just remember, so I'd probably finish there as far as the waffle. I just want to remind everybody who is Aqua members that as a member of Aqua, you have access to the telephone advice service that we provide, right? You can ring us up and get information. You also have access to the back end of our website, right? Which is accessible by password and has sample documents, contracts, letters of offer, all that bits and pieces that you might need for employing something. One thing that is going to be clear out of this whole process, and one thing probably everyone should remember, I suppose, is going forward, whatever you do, it's going to be more important that you have your initial employment documentation sorted out, right? And that could be something just as simple as a letter of offer, making it clear that the person is a casual employee rather than thing, because one of the problems with this, some of these decisions where the organisation got 10 years worth of annual leave from them, he thought he was a casual employee, he was always told he was a casual employee, but he had nothing in writing that suggested he was a casual employee. And once you have nothing in writing, you're far more exposed to these types of claims than if you have something in writing. But it doesn't mean that if you have something in writing, it doesn't mean you're completely immune either. There's things you might have to do during the course of it, say once every 12 months, once every 2 years, go to these people and say, listen, we asked you once before, but you want to, you said no then, but do you want to take a 25% pay cut and go permanent or not? Right, and most people hopefully say no. Right? But all you're doing there is complying with your obligation. You're telling them what's going to happen if they take a permanent arrangement. And some people might take it, but most people probably won't, because most of the people in the car industry are relatively low-paid workers. Right? Anyway, so access all the time. You ring us on the telephone, or you can go to our website, or you can see us in the next couple of days. So has anyone got any queries? That was a bit quick, but anyone got any queries on any questions at all? Yeah, I think we should. I should get it in the next few days. I'm hoping we'll be able to either send it out through Aqua, or Aqua have got to make that decision whether they want to get involved in this or not. I haven't asked them about it yet, but sometimes associations for commercial reasons need to stay a step back. But it should be available on our website. And if we do go via our website, we'll probably get Aqua to send out a note to everybody saying that this is out there, right? And that will give you an idea about what's going on with it. Okay. Yes. Sorry, can you speak up a bit?
Sorry. From the casual to permanent or part-time,
Yep.
wasn't there a clause about the needs of the business?
There is, but what you've got to look at is it all comes down to what the regular employment means. And regular employment is surprisingly irregular when you talk to the Industrial Commission. If you're dealing with an unfair dismissal claim or a redundancy situation, you have this concept of regular and systematic employment. And one of the cases on this thing says regular employment does not mean that it's not irregular, right? It's just the way that they stat the thing. They say it doesn't have to be the same hours every week. It doesn't have to be a fixed roster. You don't even have to tell the person, put them on a roster necessarily, and they still might find that based on the history of that person's employment, they've been considered to be regular employees, right? And it does, to a degree, mean that in certain circumstances, the needs of the business have got to be accounted for. But the history of the Industrial Commission when it comes to these things is that they find ways to benefit the employee when it comes to these type of areas. Right? So, there is some needs of the business issue, but if you have a person who's been there for 3 or 4 years and they've worked somewhere between 15 and 25 hours a week over those 3 or 4 years and, various times and that sort of thing, there's a fair chance that they'll find that is going to be regular, employment. Right? So the problem we have here with your question is a very common problem with what we do within industrial relations is sometimes you just don't know the answers. Right, and we're in that situation at the moment with several areas. We don't know how these things are going to apply when someone starts testing them in court. And when the WorkPack decision went to court, it was not too many people were expecting that come that way. But that's the way it ended up. Right? So yeah, you've got to be a bit careful. And when you're talking about 4 weeks annual leave a year, and a person's been there for say 7 years, we're talking about 28 weeks worth of annual leave. So it's a big issue for some people. Yeah? Any other questions? Can't see with these lights on. All done? Okay, sold. Right. Yeah, just come and see us if you need us, okay?
And after all that, Tom O'Toole still loves his staff. So he should have been in just before that session, I think. Thanks, Graham. That, I think, wraps this morning's sessions. But